Major twist in the Kevin Costner legal drama. Months after a stuntwoman accused the actor and his production team of sexual harassment and misconduct on set, the actor, he's firing back, calling the allegations patently false, a bold-faced lie, and says he's got the proof to back it up. We are breaking down Costner's new legal filings, trying to throw out this whole lawsuit, and we are bringing on the perfect person to discuss this, California trial attorney Neama Rahmani. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, we got this major update in the Kevin Costner legal case that we talked about several months ago, right? So the star's attorneys have filed paperwork to throw out the sexual harassment, discrimination, and retaliation lawsuit against him. Now, before I get into this latest development, if you're not familiar with the story, quick overview of the case. We talked about this, by the way, more in depth on a previous episode of Sidebar. You can check it out. It's up on Law&Crime's YouTube page. We're talking about Devyn LaBella, a 34-year-old professional stunt performer with a long resume who filed a lawsuit in California against producer, director, actor Kevin Costner, Horizon Series Inc., Horizon Series 2 LLC, and Territory Pictures Inc. Now, LaBella is suing for various causes of action or claims like sex discrimination, creation of a hostile work environment, sexual harassment, breach of contract, and she claims that in May of 2023, while filming the movie Horizon 2 out in Utah, she was asked to, quote, stand in for a lead actress, Ella Hunt. And this was during what she claims is an unscheduled and unscripted scene. And she alleges that Costner directed a violent, simulated rape scene without notice, without choreography, and without the presence of an intimacy coordinator. So you're talking numerous allegations here that this was a violation of SAG-AFTRA rules, namely that you need to provide 48 hours notice for these kinds of scenes, that the set wasn't closed, that the scene was allegedly broadcast on monitors for the entire crew to witness, that LaBella's underwear was exposed with her even menstruating at the time. Oh, and there's also the claim that the main actress, again Hunt, had reportedly refused to perform this particular scene. And LaBella says she was unaware of this when asked to, quote, stand in. And there's what she claims happened afterward. She alleges that she was blamed by male coordinators, told to stay in her trailer, was not rehired for Horizon 3. And she has claimed that she has been blacklisted from other projects by key crew members. So, she is suing for a lot. She is suing for compensatory and punitive damages, attorney's fees, a court-ordered apology from defendants, mandatory harassment training, intimacy coordination on future productions. All that's the background. So what just happened? Well, the legal team for Kevin Costner and the other defendants, they filed quite the response, and we want to get into it. So it's called this memorandum in support of a motion to strike the entire complaint under California law, this anti-SLAPP provision, which I'll talk about. But the way this starts is with an apparent text message from LaBella. Quote, "Thank you for these wonderful weeks. I so appreciate you. I learned so much and thank you again. I'm really happy it worked out the way it did too. Have a great rest of the shoot and yes, talk soon." And then there's the heart smiling face emoji and the heart clasped hands emoji. This is what plaintiff Devyn LaBella texted to her supervisor just 9 days after allegedly suffering a humiliating, traumatic experience on the set of a major motion picture for which she was employed as a professional stunt person and for which she now seeks millions of dollars in damages. There was no anger or resentment, only enthusiasm and gratitude. The reality, as supported by the sworn testimony of a dozen respected veteran film crew members with personal knowledge of the facts at issue in this dispute, real-time photographs of the shot in question, and LaBella's own words at the time, is that LaBella's opportunistic and salacious lawsuit is just as fictional as the motion picture at the center of this dispute. Now, we've been following this Kevin Costner story. We're going to continue to follow it. And one of the reasons we can do that is because of the incredible support that we get from our sponsor, OneSkin. So let me ask you something. Have you heard about this? Have you heard about OneSkin's scalp serum, the OS01 hair? People are raving about this. If you're familiar with OneSkin, you know about their patented OS01 peptide, how it's scientifically proven to target aging at the cellular level. It's what powers their skin and sun care. Well, now it's targeting age-related hair loss and thinning. So listen to this. People are sending in reviews like, my hair has never felt this thick and full. My scalp feels healthier than ever. And I started 3 months ago and I'm seeing new little hairs in my scalp line. One customer even wrote, I've tried everything for hair growth and finally I'm getting a response from my hair. And it's not just talk. OneSkin scientists, they did a clinical study showing that after 6 months, participants had significantly thicker and denser hair. And that's one of the things that I really love about OneSkin. It's the science. Their OS01 peptide is the same one that's also behind their cult favorite skin line. So I was thrilled to hear that they also have this product to support hair longevity at the root. Literally. By the way, I care about that. So OneSkin is the world's first skin longevity company. By focusing on the cellular aspects of aging, OneSkin keeps your skin looking and acting younger for longer. So for a limited time, you can try OneSkin with 15% off using code SIDEBAR at oneskin.co. That's 15% off oneskin.co with code SIDEBAR. And after you purchase, they're going to ask you where you heard about them. Please support Sidebar and make sure to tell them that we sent you. So basically, Costner and the other defendant entities are calling her allegations factually incorrect and that her claims are meritless. First, there is an argument that they say no rape scene was scripted or filmed, that the film includes off-screen depictions of 2 violent rapes as part of the narrative, but no actual rape scene was filmed or scripted, that LaBella's complaint centers on a single unfilmed, quote, pickup shot that was rehearsed or blocked with her involvement. Second, they say that the disputed shot involved an actor, Roger Ivins, lifting the hem of LaBella's dress from ankle to knee, but that LaBella was fully clothed under her dress, wearing multiple layers, including petticoats, pantaloons, and bike shorts. That there was no nudity, there was no struggle, there was no simulated sex involved in any of this. That this lasted only a few seconds and it wasn't filmed. And, they argue, that LaBella consented after the stunt coordinator explained the scene to her, with witnesses reporting she was smiling and laughing and gave thumbs up during the rehearsal. So from there, Costner argues that the next day, LaBella expressed discomfort to a production assistant director. And she reportedly said that she was upset not because of the scene itself, but because she was on her period and was afraid someone saw her underwear. She allegedly continued to work for another week with no signs of distress and even took her supervisors out to dinner to thank them. And they also say that in a post-shoot text, she allegedly thanked her coordinator for these wonderful weeks. Now, Costner also highlights how LaBella has no competent or admissible evidence to support her claims, and that they could cite multiple witnesses and multiple declarations stating that the scene was harmless and consensual. Now, let me get into the law a little bit, the legal argument. So the main idea from Kevin Costner and the other defendants is that LaBella's claims arise from protected creative activity related to the making of this film, which is constitutionally protected speech under the First Amendment. That the lawsuit should be struck under California's anti-SLAPP statute because it targets conduct in furtherance of public interest expression. In other words, storytelling about historical trauma and violence, that's what we're talking about, that the anti-SLAPP law protects free speech by stopping people from using the legal system as a weapon to chill speech, to silence others when they're talking about matters of public interest. And I'm going to expand upon that because they argue that they have satisfied 2 prongs of the required legal test here. 1, they say there is in fact protected activity. And 2, they argue that the burden shifts to LaBella to show a likelihood of success on each of her claims and that she can't do it. So they argue all of her claims stem, again, from this single blocked camera shot, that this is a part of a film direction, that this is part of acting, that this is clearly expressive activity, that it is free speech, that is protected under the First Amendment, that her other claims, like not being rehired for Horizon 3, that's about casting decisions, not retaliation. And casting decisions is a protective, creative decision. They also argue she wasn't actually assaulted, that the blocking of a non-sexual scene was part of the filmmaking process. Now, what about to the argument of this is a matter of public interest and it's protected? Well, the argument is you have a film that is dealing with serious historical themes, including the vulnerability of women during westward expansion, that the Horizon Project is widely covered in the media, and you got Kevin Costner involved. He is a high-profile star, and his status makes the project and this lawsuit newsworthy. So the media attention and the public interest surrounding both the film and the lawsuit, the argument is, further solidify that this is a public issue under anti-SLAPP standards, and it's protected. So all in all, the main idea is that LaBella's lawsuit is an attempt to suppress or punish protected creative expression, and because her claims arise from protected activity and fail to meet the legal threshold for moving forward under the anti-SLAPP statute, they ask the court to strike the complaint. But then we go into the next part, that LaBella can't show a probability of success, and they break it down cause of action by cause of action, count by count. So let's go through it. Counts 1 through 4 are sexual discrimination, harassment, and hostile work environment. The defendants argue that all 4 claims are based on that single event, the blocking of that simulated rape scene. And remember when LaBella claims that she was directed to perform without prior notice or consent? They argue she doesn't allege any job benefit was tied to her participation, that she wasn't threatened, that she consented after the shot was explained. And in terms of hostile work environment, there was no pervasive or severe conduct that was alleged, that a single incident, especially one that was allegedly consented to and involved no nudity or actual sex, doesn't meet that legal burden, that legal threshold, that she wasn't targeted for her gender, she wasn't injured, that she didn't express any concern at the time. That's their allegations, that's their narrative, that she allegedly thanked her supervisor and continued working afterward, meaning these actions are inconsistent with someone who perceived a real hostile environment. Count 5, failure to prevent discrimination and harassment. The defendants argue that if there was no actionable harassment, then this claim automatically fails, right? LaBella's employer had standard anti-harassment policies, which she received, they argue. They say there was no nudity, there was no sex, so there was no requirement for extra precautions like an intimacy coordinator or a closed set. So it seems like they're actually maybe fighting that point. And when the plaintiff finally did raise concerns, they argue they were reported and they were investigated appropriately per the proper guidelines and procedure. Counts 6 and 8. Retaliation and intentional interference. So they argue there was no evidence of retaliation against her, that she continued working after raising her concerns, that she was praised and invited to continue, and not being hired for Horizon 3 isn't retaliation. The character that she doubled for isn't in the sequel. That the supervisor simply really didn't have a reason to rehire her, as with many other stunt performers. And finally, they argue there's no causation, there's no causal link between her accusations, her complaints, and the alleged harm, meaning not being hired again. Now, when it comes to count 7, this is a Bain Act violation, so threats, intimidation, or coercion. They argue that doesn't exist here, that LaBella doesn't point to any threatening words or actions, that she may claim that she felt pressured to Costner's authority, but there's no evidence of actual intimidation or coercion, that the Bain Act violation requires something more than perceived authority, requires threats or actions implying violence, which are absent here. Then you have breach of contract, so this is count 11. And they argue, wait a minute, there's no specific contract provision that was breached, that LaBella failed to point to a contract term that was violated, that she references someone else's contract, right, Miss Hunt's, the one she was standing in for, but she herself isn't a party to that contract or a beneficiary to that contract, that her own contract didn't require the specific precautions she now claims were missing. And they also say there was not a nudity or sex scene, so the SAG-AFTRA provisions for such scenes don't apply. And then you also have count 10, intentional infliction of emotional distress. The defendants argue there was no outrageous conduct which is required under this claim, that blocking a scene with prior explanation and consent is not conduct that, quote, exceeds all bounds of decency, that there was no intent to cause harm, that the plaintiff was informed and agreed to participate, that there was no severe emotional distress, that LaBella allegedly continued working that she went out to dinner with her supervisor and she expressed gratitude. And one more thing we got to talk about is another filing from Kevin Costner, too. Actually, it is a declaration from Kevin Costner. And what does he say right in this document? Here's a sample. Devyn's claims against me are absolutely false, and it is deeply disappointing to me that a woman who worked on our production would claim that I or any other member of my production team would make one of our own feel uncomfortable, let alone suffer the nightmare she has invented. My belief is that Devyn's claims were designed through the use of false statements and sensationalistic language to damage my reputation. These allegations are so patently false, I can only assume that the purpose was to use this sensationalistic language to embarrass and damage me and the Horizon movies on an ongoing basis in order to gain a massive and unjustified payday. Equally as bad, having to read about and address allegations I know to be false involving the words rape and assault has been an absolute nightmare. The truth matters. That's why, even at the high cost of this lawsuit, financial and personal, I will always speak up to defend myself and my crew against false allegations. I have worked with many on this crew before and know they care deeply about each other and the important stories we tell. They, like me, do not deserve to have their reputations impugned by opportunists making false claims. Yeah, so Kevin Costner calls LaBella's claims of being forced into this unscripted rape scene patently false, a bold-faced lie, a blatant lie designed to damage his reputation and the Horizon films. And he asserts that the contested moment was not a simulated rape, but rather, quote, one artistic shot designed to imply what was going to happen off screen. And as part of this filing, Costner submitted photographs from the set that allegedly show LaBella smiling and appearing at ease during rehearsals. It is being reported that other crew members filed declarations backing up what Costner said. And Costner also apparently highlights a positive text message that LaBella sent afterward expressing gratitude for the experience. Quote, "Thank you for these wonderful weeks," that text. All right, I want to bring on right now renowned California attorney, litigator, former prosecutor, trial attorney Neama Rahmani. Neama, thanks so much for coming on. What are your thoughts on this filing? And by the way, what exactly does it mean that they're trying to strike this on anti-slap grounds?
Jesse, under California law, you can strike a lawsuit using this anti-slap statute, and that really stands for strategic lawsuit against public policy. And what happens in these types of cases when you're dealing with an artist, they will argue that the lawsuit infringes upon the First Amendment. And the argument is this is an artistic scene. Even though it's a rape scene, it's a sexual assault, this is something that you agreed to do. This is something that's covered by the SAG contract. There's an intimacy coordinator there, and you can't raise this type of argument because it violates the First Amendment. So procedurally, it's important because it puts the lawsuit on hold. You can't conduct any discovery. And if the defense wins, the plaintiff, in this case, has to pay the attorney fees. And even if they lose, the decision to deny the slap motion is immediately appealable. So again, puts the case on hold while the case goes up to the Court of Appeal.
Is this a strong argument here? Because what you have are two radically different narratives about whether or not what the scene was about and what happened. Do you think that the court would dismiss it at this stage?
I don't think it's a strong argument, but I got to tell you, Jesse, because we represent plaintiffs in these types of cases, I have seen judges consider this, dismiss maybe part of the case, some of the allegations. It allows the defense to go up on appeal, put the case on hold, make the lawyers incur more costs. So it is strategic. Do I think the case is going to be dismissed entirely? Absolutely not, because even a text message that the plaintiff sent isn't dispositive. That's more of a question for the jury, but it could absolutely delay things. And it's a strong strategic move by Kevin Costner and the defense.
One of the things they say is there's no evidence, right? They say she has no evidence to back up her claims. But again, isn't that too premature? Doesn't that come down to this is litigation, this is discovery? You don't have to put all the evidence to prove your claims at this point in the case?
Well, her own words are certainly her evidence, and them saying that they don't have a contemporaneous complaint, that doesn't necessarily mean that the harassment didn't happen, right? Oftentimes victims, especially when there's a power disparity, especially here in Hollywood, right? We've seen it time and time again where, let's say, even in a Harvey Weinstein case, right? Someone maintains contact with their abuser. I'm not saying that allegations have any merit, but that's really more of a question of fact for the jury, not necessarily something that the judge is going to rule on as a matter of law.
One of the things they talk about a lot is that she can't show a probability of success, and they break down each cause of action, each count, about why she wouldn't be able to show that. Do you agree?
Again, I'm a plaintiff's lawyer, so I don't agree, but this is what the defense does all the time. They don't want this case to go anywhere near a jury. I'm telling you this right now, and I'll call it. If it's not dismissed at the slap stage, if it's not dismissed on summary judgment, the case is going to settle. Kevin Costner is not going to want to have to litigate a case like this. He's got bigger fish to fry. So what the lawyers do is try to get the case knocked out by the judge before the jury part of the case. And if not, we'll probably see some sort of mediation in the settlement.
He provided a declaration as part of this filing, and it's quite the declaration. I was reading parts of it before, basically saying this is a blatant lie, how it's been a nightmare. These allegations are absolutely false. Why did he put that declaration in there, and do you think it was important for him to put that declaration in there?
Jesse, sometimes things are done for the courtroom, and sometimes they're done for the court of public opinion. And oftentimes in these types of cases, the best defense is a good offense. You want to come out strong, let the plaintiff know that this isn't going to be a quick settlement. This isn't something that's going to resolve by a demand letter or a mediation shortly after filing. Now that you've made these very serious accusations and they're all public and Costner's reputation is tarnished, he's going to dig in his heels, and he wants to send a message to the plaintiff or a lawyer, but the public, that he is not a predator. That's why that declaration was in there.
And he submitted these photographs from the set. The argument would be it shows that LaBella's smiling, she's appearing at ease during these rehearsals. Do you think that's significant?
I think it is significant. There's a couple things that really come into play in a lot of these cases. And we talked about Weinstein, we talked about Diddy. And again, those are very different cases. They're criminal cases. But I think what is important and what jurors want to see is a contemporaneous report, right? If you're being harassed, you go to HR, you tell a friend, you tell a coworker. If you raise the allegations years later, that's not to say it didn't happen, but it does play into the defense that this is all fabricated because of money, because of fame, because of revenge. The other thing I think that is important is what we've already seen, those text messages. If there are communications with the abuser, with folks on Costner's team, and they don't raise any of these, and in fact, they're the opposite, they show someone who's happy, again, that still is not inconsistent with the harassment or the abuse happening. But again, makes the case much more challenging to prove. And it doesn't matter if you're a prosecutor or a civil plaintiff's lawyer.
And the idea, this allegation that there are other people, other crew members that have filed declarations backing up Kevin Costner, couldn't 100% confirm that. That seems to be what is being reported on. That would be significant for him.
It is. Obviously, look, it's not a numbers game. It's not like we have more witnesses on one side versus the other. There's a jury instruction that says you're not supposed to do that. But if you have witness after witness saying, hey, I was on set, and even according to the plaintiff herself, there was approximately 100 people on set, and they say none of this happened, that's going to be a very difficult case to prove. Now, of course, the plaintiff will argue that, look, these are people on Costner's payroll. They have a reason to lie. They're loyal to him. Otherwise, they'll lose their job. But if you have witness after witness saying the same thing, it's the type of case that could go sideways really quickly for the victim.
Neama Rahmani, thank you so much. Appreciate it.
Of course, Jesse, thanks for having me as always.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.